Welcome back, Matt.
Thank you so much,
my
Nana. It's lovely to
gosh.
be back and making an
Yeah.
appearance on the Friday Workplace
I
Briefing
know.
again.
I think everyone will be excited to not see Andrew for once.
I know. Our intrepid leader on a break again, not again, enjoying himself in Port Douglas, which makes me think I should look out for a port reading holiday one day. But nonetheless, who knows why he chose where to go.
I think the weather. Like, we've been having terrible weather.
That's
really.
fair. Probably a reasonable choice on Andrew's behalf there, for sure.
So a lot of things we have to cover because it's essentially 2 weeks now that we're covering.
Absolutely,
these
with the
items.
Easter break, for sure.
Yeah. So over to you, Matt. What's new with the Fair Work Act?
Yeah, well, it's still long and huge, and the Labor government is still choosing to put some big things into it. Look, we're predicting, and what they're saying is bigger changes coming in the second half of the year, but they've done a little bit more smaller tinkering post the Secure Jobs Bill. Really, a couple of things they've sort of put in. They're going to put in an entitlement around superannuation into the National Employment Standards, which I do think is a really big one.
Yeah,
A little bit of tinkering about flexible days of parental leave and
an increase to the amount of days.
That's right. Yeah.
Yeah.
Well, that's for the flexible days, which is this additional entitlement. And look, and are really making very clear that the entitlements under the Fair Work Act do apply to migrant workers. It's always been the case, but it's a classic example where they've just wanted to
reinforce it.
Yeah, that's right, because there's a lot of dispute that sits around that all the time.
Yeah. All right. And so the first case we have is one which we've actually talked about before. It's about accessory liability for HR managers. It's United Workers and Burma. And this is the crazy case where you had an employee who was being performance managed for something. HR manager starts a disciplinary meeting. Employee walks out. She's really distressed. Goes home.
Not uncommon.
Yeah. HR manager calls for a welfare check, right? Employee is too distressed. Hands the phone to her husband. Husband says, she's not talking to you. You're bullying her. HR manager hangs up. Then later that day, sends an email saying, we accept your resignation. So as you can imagine, the Federal Commission was Federal Court was very scathing about it.
Yeah, I believe it.
Clearly, it was a constructed dismissal, and they had always intended to dismiss her. And this was the sentencing. So she won $47,000 in economic loss.
Yeah, not an insubstantial amount.
$9,000 in general damages. And most importantly and relevantly, is that the HR manager was fined over $7,000 personally because clearly their actions were intended to breach the Fair Work Act. It's crazy stuff.
Yeah, can't throw around resignation like that when you haven't got a very clear verbal or written one.
Yeah, and what was really clear about this case is didn't even check with the employee to confirm that it was a resignation. Had heard through another person, didn't know if they had the authority. So just crazy stuff, and I don't know why they ever thought they'd get away with it.
No, absolutely no, crazy.
Okay, so unreasonable hours, Matt. There's a hot topic at the
moment.
moment.
My goodness, yeah. Well, look, anyone who's into politics knows it's a big issue amongst the independent members of Parliament at the moment, with the member for Kooyong, Monique Ryan, and her sort of former employee Sally Rugg. That's a big case in the employment space, which looks like it's likely to head to a decision about look, what is reasonable overtime, what is, when you look at the full-time 38 hours, what makes it reasonable, when can an employee refuse, and so on. So it's a big hot button issue, and in the context of that, we've had this case pop up. Here we just had an employee terminated before the end of their probationary period, effectively made several complaints in the course of her employment about working unreasonable hours. Now, when this case was decided, she actually did technically lose on this aspect. So she didn't provide any evidence to the employer and therefore to the court to actually demonstrate that the hours that she had worked were greater than what her contract recorded. So she didn't, create her own timesheets or anything contemporaneous. So that actually saw her unreasonable hours claim fail. But what it did get over the line in this respect was a bit of a backdoor sort of general protections claim, whereby she was able to establish that, notwithstanding that she didn't have the evidence to support those claims, her making of those complaints and inquiries about the unreasonable hours were accepted to be valid complaints and inquiries. and the employer was unable to discharge the reverse onus. So it claimed that it had terminated her because she was effectively a classic poor fit. It couldn't evidence that before the court. So in that circumstance, the court accepted that the complaints and inquiries were at least one of the reasons for the termination of her employment. So doesn't quite get there. We're going to see a lot more, I think, once that this very high-profile Monique Ryan and Sally Rugg matter goes all the way, and us employment lawyers are chomping at the bit to get a bit of case law.
And the FSU test case that they fought too against NAB. So
that's right.
It's a reminder to make sure that you are checking the hours of your employees, because I think it's about to shake it up.
Yeah, absolutely.
All the industries,
remembering that they need to be reasonable. It's a huge thing.
Okay, and we have another unreasonable case, this time about whether, something is reasonable management action or not, because that's the all-important question when it comes to workers' comp. Yeah. So this was a really interesting case because this employee had quite a difficult relationship with their manager. The manager was one of those very direct managers, as we all know those kinds of people. And the employee worked in the countryside, so it was a fairly long commute and often had to vary their hours accordingly. So with the incident in question, they had a tradesperson who rocked up late that day, and so unexpectedly had to work from home. They texted the manager, informed them, all good. Manager didn't say anything, didn't speak to them the next day when they were in the office together, kind of didn't say anything. But then the day after that, sent them a scathing email saying, how dare you unilaterally decide to work from home? You're not authorized to make those decisions. You just blasting them. And of course, the employee very rightfully filed a workers' compensation claim and won. Because although, yes, you should be speaking to employees if they're not going through the proper processes in how they're notifying you, or how the flexible work policy is being. There's a reasonable way to do it.
Absolutely.
And that's the key thing when it comes to reasonable management action. Whatever action you are carrying out, you have to be able to evidence that it was reasonable in the circumstances.
Yeah, and carried out in that reasonable manner. Yeah, no suggestion here that that employee was perhaps in the right to unilaterally decide to work from home, but that failure to follow up contemporaneously, that delay, especially the period in between, just being like everything's
they
fine.
Saw them.
Yeah,
like, why didn't you just talk to them then?
Absolutely.
I think it's also a reminder, which is really important, to have those discussions with your employees. There's a tendency to let things build up over time and put things in writing. And as we know, things in writing can be misconstrued.
Absolutely.
They come off as more harsh. Just have the discussion in person and then convey it in writing.
Yeah, trade off that relationship you've got built with the employee. Exactly. Absolutely. Yeah. All
right. On to the next case. Ooh, flying through these cases, a lot of them.
Yes, yeah.
Yeah, so this was a
soccer.
funny one, and I'm very proud of the heading that I created for this one. So one of the WorkPack employees injured themselves when they were playing in a workplace soccer match. So WorkPack engaged, I think it's another company called Sodexo, to organise sports functions for their employees. And WorkPack said, look, we shouldn't be liable for any injury because it's not to do with work. There's no connection to the employment. And this was an appeal case because at the first instance, the court found, well, no, that's not true. There is a connection because WorkPack had induced or encouraged the employee to participate in this activity. And it's an interesting discussion because WorkPack said, well, no, we didn't say, you have to go join this soccer club. It was just an option available to all employees. So that's not encouraging or inducing them to do so. And the appeal court said, no, the test actually is the fact that in their policies, WorkPack said, look, you have to comply with any policies and procedures of any of our third-party people, including Sodexo. And in Sodexo's policies, they had an invitation to join this sporting club. And by the employee taking that on, that was enough to meet that test.
Yes.
So it's really interesting and real narrow. And it's just a reminder to be careful about how things are drafted in contracts because they can have unintended effects.
Absolutely, yeah. Particularly in the pursuit of what would be, objectively speaking, a good outcome for getting your employees to be active in that space. But yeah, unintended consequences from drafting. Always go back to the drafting.
All right, and very quickly, Matt,
Yes,
tell us about EBAs and negotiating with the union.
Yeah, look, it's a great,
without the union.
No, well, look, it's a fantastic example. A question I get asked so often in the industrial space is, look, if we reach an impasse in negotiating with the union, can we put the enterprise agreement to a vote? And this case, a great example to answer that question. Absolutely, yes, with some understandable usual caveats. So, look, context of this one. Yeah, for MSS, they didn't necessarily want an agreement. They didn't want to start bargaining. The CFMMEU got a majority support determination, required the MSS to come to the table to negotiate. MSS then did engage in like a really well-structured, considered...
Yeah, they went above and beyond.
Yeah, they really did meet the good faith bargaining requirements. They had several meetings, they provided explanations, they informed the union of their views, they engaged actively, proactively in many ways and openly. It ultimately reached an impasse, and MSS decided, well, look, and told the union we're going to put it to the vote. Now, the vote was actually unsuccessful in that first instance. And what they did then, because they were getting that impasse from the unions, they actually went and spoke to the employees directly. The employees sort of said, look, here's our two actual major issues, and one was about annual leave, one was about sick leave. The union then found out about this and said, well, how come you've gone straight to the employees? And MSS said, well, look, we've tried to go back to you. And then they even tried again after that to engage with the union. Ultimately, they did get some further negotiation, which then again went nowhere, and MSS intended to go for the vote. So the union here actually brought an application to intervene to stop the vote. And the commission said, well, look, you've got no basis for this, really. Everything I see here on the evidence that I accept is that MSS have gone above and beyond. And in those circumstances, it's entirely lawful for them to speak to their employees. They weren't trying to cut out the union. The union had effectively cut themselves out. So what it's a really great reminder of is, yes, number one, if you do get to that point, you can put the agreement to a vote directly with the employees, but also be the bigger person when it comes to this process, because it will pay off. You might want to get down in the dirt with the union, but try to avoid it. Be the sort of paragon of virtue here when it comes to this, and it'll pay off in the end.
Yeah, it's an important lesson.
Yeah.
All right, on to the main topic. So this is a question we get asked all the time, it's an important one to bring up because there was a recent case, the Serco case, which, look, the facts aren't that important. It was a dog handler who was being investigated because they found his dog was injured and they wanted to figure out why. He refused flat out to participate in the investigation, said it was a fishing expedition, a dog hunt, you might say. And basically was like, no, I refuse. They subsequently terminated his employment, and it was found that by failing to comply with the lawful and reasonable direction, that was a sound and defensible reason for termination. So that just brings us back to this discussion where if you've got an employee who's been accused of misconduct, what do you do if an employee says, no, I'm not going to entertain this process?
Yeah, and look, I think, investigations are often, they're quite emotive, they're quite highly charged, and I think all of us fairly would say, look, no one likes to be accused of anything, and no one likes to be put under the microscope. So it's very easy when you are an investigator, if you are a HR person, and you're sitting down to start this process, you might accidentally put your own lens to it and go, okay, well, if I need to get this employee to come and speak to me about these allegations or about this as a witness, whatever it might be, and I wouldn't necessarily want to be that person too. So you tend to be a little bit more receptive when an employee does resist that overture to come and be part of this. The important thing I think that is forgotten often in this is if you strip away the sort of interpersonal conflict and the emotiveness of it, it does come back down to the lawful and reasonable direction inherent in asking an employee to participate in a workplace investigation.
Yeah. There's no unfettered right for them to say, no, I automatically don't have to participate.
That's right.
Yeah. And look, yes, there is, that implied one, but we always recommend that you, in any correspondence, you make it clear that it's a lawful and reasonable direction,
Yeah,
that they have to participate.
yeah.
Emphasis on the reasonable.
Yeah, because the lawful's very technical, but it's basically always there in respect of an employee. It's either implied at common law, it's the duty of control, it's all those aspects that are inherent in employment. Where people more often than not trip themselves up here is the specific context of an employee and that question of reasonableness. So yes, it's always going to be lawful to ask, but is it reasonable in the context of that specific employee? And look, 9 times out of 10, thankfully, unless the employee, has raised something that's valid, it is largely going to be reasonable to direct an employee to participate in an investigation in that way.
So when we're talking about when it might not be reasonable, it's more situations where the employee has asked for a delay because, say, they're not feeling very well, they're feeling psychologically stressed by it, and maybe need like a day off to like consider everything and come back fresh faced. That's fine. Like it wouldn't be reasonable in those circumstances to say, no, you have to come in now and respond.
And a common error too, because look, we talk a lot about how process in investigations is really important. You need to be regimented about documenting things, conducting meetings in particular ways, support people, all those different aspects. But it always, because of this overarching umbrella of the lawfulness and the reasonableness of it, you do need to be prepared to be adaptive to the particular context. Again, something we quite often see, we largely, a lot of questions all the time. I've got an employee who says I wanted to have the investigation meeting today and it's, Thursday and they can't attend until Monday. Oh, okay, well, that's a little bit frustrating, sure, but what really turns all that much on 3 working days difference?
Yeah, I think that's the key thing, that it's got to be a reasonable request from both sides.
Yes.
So if they say, look, I'm not going to respond for 2 months, obviously that's not going to be reasonable. And the other thing to remember is a common request is, look, my union representative's not available for like another week or so I want to delay it back then. Look, in those circumstances, it's probably not as reasonable depending on the length of delay, because the purpose of the investigation is to obtain their true versions of facts. They can have whatever support person they would want during the process, but it's not the time for someone else to advocate on their behalf, because it's not a disciplinary meeting. It's simply obtaining, the true version of events.
No, absolutely. And look, the obligation when it comes around support people in this context anyway is that you've offered them the opportunity to have one, not offered them the opportunity to have a specific person at a specific time and so on. So I think that's a great example of where that reasonableness needs to be taken into account. The other, of course, is where, you do get the medical certificate. You've got the employee, they say that they're stressed. I mean, when it can be dealt with in a much more straightforward way. If you've got the employee presenting to you saying, I'm stressed, the physical manifestations of it are there, well, that's a really easy trigger to take a step back. When you get the medical certificate, it doesn't mean you need to panic right away. What you might then need to do is just adapt your process a little bit. Is there an opportunity to extend an invitation to respond in writing and so on and so forth? So, really always coming back to that point of the reasonableness to say no unfettered right for an employee just to refuse to participate. But as many things are in employment law, it's contextual. Don't try to treat everyone, paint them all with the same brush. You've got to look at this on an employee by employee basis.
And just before we move on to the case study, I also want to just emphasize that these same rules that apply to the respondent to any allegations also apply to any other potential witnesses. You might have witnesses who say, I don't want to get involved in the investigation, it's too messy, I don't want to get involved. They have the same obligations to comply with lawful and reasonable directions. And there's also other considerations, like say it was a safety investigation, their failure to cooperate there would be a breach of their duties towards the other employees.
Yeah, absolutely.
So same duties apply to all witnesses in.
We're not just talking respondents here.
All right, so on to the case study, and it is a long one.
Andrew put some extra detail into this one just for fun.
I knew you were coming back.
I know, that's right. All right. Mandy worked with aged disabled people in their homes. She was a carer. Her boss was Joe. Joe, as part of his OHS system, was undertaking risk assessments for new clients and updating assessments every 6 months for existing clients. He approached Mandy about her 2 existing clients. Mandy explained that these were very private people and she would not be happy for Joe to do the assessments. Joe explained that it was his responsibility, it was a fresh set of eyes, and also provided a window into how the clients saw the support they were given. It was not just a safety assessment, it was a client survey. Mandy became very offended and said, "So you are going to spy on me and not respect these people's privacy? My relationship with them is very special and I don't want you prying and damaging that."
That doesn't sound creepy at all.
No, it's weird, isn't it? Yeah. The next day she visited the Lemke's house. They were an aged couple and the husband had profound physical disabilities from a stroke, and his carer wife, though strong and fit, was starting to exhibit memory issues. Mandy took a call from Joe while she was at the Lemke's home. After the call, she said to Bob Lemke, "My boss wants to come out and grill you about me and prove that you can't be looked after at home." Well, there it is. Bob Lemke rang the organisation hotline the moment Mandy left and asked to be put through to the big boss. He was put through to Joe's boss. The next day, Mandy received a text to ring HR. She rang straight away. Dion, the HR manager, said he needed to speak to her about a conversation she had with her clients, the Lemkes, yesterday. Mandy hung up. She then sent a text instead, "How dare you dig into my client's privacy?" Dion texted back and said they had made a complaint about her and so had her boss, Joe. Dion said he would see her at work at 10 a.m. tomorrow. She may have a support person with her, and Dion will provide her with the letter of allegations. Mandy sent in a doctor's certificate the following day. It said she would be unfit for work for 2 weeks and likely longer, as she is suffering from PTSD, depression, and anxiety. Oh, and anxiety, really. A week later, her psychologist sent a note saying she would be unfit until further notice, but no less than 3 months. After 2 weeks, Dion sent the letter of allegations. Included in it was contact details for EAP and other support, and said he required a response in writing within 7 days, or alternatively, he would be happy to meet with her and a support person before that time. Mandy wrote back saying the letter was bullying. She was unwell and it further harmed her health. Dion wrote a further letter in a sympathetic tone, explaining in the absence of medical evidence she was not fit to answer the allegation. If she was not fit, she was required to answer them. It was a lawful and reasonable direction. He said he would welcome any fresh medical evidence, but in the absence of that evidence, he would conclude the investigation based on the witnesses he spoke to and her refusal to answer questions, especially as it involved him having to speak directly to a vulnerable and distressed client, breached her obligations to the organisation and may in itself be serious misconduct.
It's never ending.
No, Mandy sent back a text saying, "Stop threatening me, I'm sick," after the 7 days passed. After the 7 days passed, Dion concluded the investigation and found the allegations proved. All right.
Okay.
Yes. And he did. I think he terminated the employment. I can't remember. Yeah, I think that might have fallen off there.
Yeah.
But yes.
Yeah. So definitely proved and terminated.
Yes.
Yeah. So was Dion's approach to question Mandy in light of her alleged medical condition a lawful and proper process? Yeah. I'd say so.
Yeah. Look, again, I mean, this goes to what we were speaking about earlier. You know, we do have to deal with the particular context of the particular employees, but a complaint's been raised by the 2 clients and from her direct report, so there's a proper basis to commence an investigation. He's then gone about it in a very even-handed way.
Yeah,
he's tried to accommodate her. And look, given her medical condition, importantly, there's nothing in there
no
that
medical
said,
evidence.
and he even asked you, gave her the opportunity for it, but there was nothing in there, and this is something we deal with all the time, nothing in there to indicate that she was actually incapable of responding to questions.
And he gave her several different ways to respond.
Yes.
Like in writing, you want to meet with me. He went above and beyond, so definitely lawful, proper process.
Yep.
Did Mandy's resistance to assist Joe with the client assessment process amount to serious misconduct? And if so, why? Yes.
Yeah, absolutely.
Definitely Regulation 1.07.
Oh, for sure. I mean, look, this is a classic example of an employee trying to stand in the way of the sort of performance of the work of the business, right? Like here, we know that Joe had said It's an OH&S assessment, so number one, that's really important. But it's also part of him discharging the duties of the business. The business needs to know what the feedback and assessment from the clients are about certain aspects. And her standing in the way of that really is serious misconduct, because she has a duty to cooperate. She has a duty to comply with lawful and reasonable directions. Now, look, maybe Joe didn't formalise the lawful and reasonable direction.
I think it was implied.
Well, that's exactly right. There is no suggestion that every lawful and reasonable direction has to be carried out in that way.
No.
It's got to be, so direct and in writing. So, absolutely.
And particularly as they were dealing with, older patients who, like, their safety considerations probably changed. If something happened to them, the company definitely could have been prosecuted. So definitely serious misconduct. Did Mandy's comments to Bob Lemke amount to serious misconduct, and if so, why?
Yeah, look, I think it certainly was misconduct here.
Yeah, this is the one where she told the client. That's right.
So, look, she was dishonest based on our understanding of the facts. So I think there's a basis to say that does get to the serious misconduct threshold.
She's definitely not acting in line with the duty to act in the best interest of the business.
No. And if we assume, of course, that there's something written like that into a contract, which every contract should, I think that's a pretty clear example. If we, even if it didn't get that high, that sort of direct disparagement of the business, it would not be hard to get that over the line as misconduct at the very least.
Yeah, terrible. Did Mandy's refusal to participate in the investigation process amount to serious misconduct? And further, would it be reasonable to say the refusal undermined trust and confidence in the ongoing employment relationship?
Yeah, well, look, again, a duty to cooperate with the employer implied a common law here. So she has failed to cooperate with what the employer wanted. And again, the lawful and reasonable direction. So again, it's lawful on the basis of all those common law duties, and it was reasonable in this circumstance. There was a serious complaint made by two clients, and from her direct boss about her conduct in the workplace. And then that's the proper basis to go with the investigation. And then she's just outright refused. Then she's provided the medical evidence. Yes, she's entitled to do that. There's then been that further opportunity provided, and instead of engaging with that, she's just outright refused to participate at all. So at the end of the day, her refusal wasn't based on anything valid or protected for herself.
Exactly. Okay. Is there any more questions?
Yes. Yeah, we do have more questions.
If Dion proceeds to terminate Mandy using a correct process, could Mandy successfully mount a general protections claim? So this is an interesting one, because I think everyone goes to temporary absence. She was sick. She was sick for up to 3 months, not more than. So, that doesn't meet the temporary absence test, but it's a complete red herring by Andrew.
Absolutely.
Because
classic Andrew red herring.
It wasn't the reason for the termination. It wasn't even in the decision maker's mind. So you couldn't ever say it was a substantive and operative reason. Time and time again, we have clients who are undertaking, an investigation into serious misconduct. The employee goes on sick leave and they say, oh my gosh, we can't do anything.
You got to drop it,
Yeah, it means that we're basically shackled to this employee. That's not true.
No.
Like, if you've got genuine valid reason that has nothing to do with a workplace right, then you can well and truly terminate on that basis. Yes, she might mount a general protections claim, but she's never going to succeed if you've got the evidence.
Absolutely. That's the key part. Never going to be successful in those circumstances, for sure.
Yeah. So could Mandy bring a successful workers' compensation claim?
Yeah, look, again, no. I mean, the carrying out of the investigation was done, clearly documented. It was reasonable in that context. But then again, Dion has gone above and beyond to be reasonable in the circumstances, giving her the time, accepting the evidence, inviting more evidence. Those are things that are going to demonstrate that carrying it out in a reasonable manner to really, stymie that application.
And the last one, could they say psychological hazards? Look, she might try to say it was bullying or something like that, but if they investigated, they'd say this was things that had come out of a lawful and reasonable process, so she'd never succeed with WorkSafe either. Cool.
All
We
right.
just made it in
Yeah,
time, Matt.
I know, we did. That's right. The 11
Yeah.
slides. Yeah, there you go.
Yeah,
Well,
this is Andrew's fault though.
no, that's right. That's fair.
But-
He left us with a good one, didn't he? Yeah.
Thank you all for watching.
No,
Please
thanks for
give us a
tuning
thumbs
in.
up and catch us next time.
Yeah, see you again soon.
Bye.